If you're a naturalized U.S. citizen who's been watching the news lately, you've probably felt that familiar knot in your stomach. The headlines are everywhere: immigration raids, deportation numbers, executive orders, policy overhauls. And somewhere in the back of your mind, a question keeps surfacing: could this affect me? Is my citizenship actually safe? You remember the journey, the years of waiting, the paperwork, the anxiety before your naturalization interview, the moment you raised your right hand and took the oath of allegiance. That day was supposed to mean security, permanence, the end of immigration uncertainty. But now, in this climate of aggressive enforcement and heated immigration rhetoric, that certainty feels shaken. You're not alone in feeling this way. Thousands of naturalized citizens across America are quietly asking themselves the same questions, often too anxious to say them out loud. I'm here to give you something that's been missing from most conversations about immigration in 2026: clarity rooted in constitutional law, not political spin. My goal today is to separate legitimate legal protections from unfounded fears and to help you understand exactly where you stand as a naturalized citizen. By the end of this analysis, you'll know precisely what your citizenship means under the Constitution, what denaturalization actually is and how rarely it occurs, what current enforcement policies can and cannot do to citizens, and most importantly, what practical steps you should take right now. This isn't about minimizing real concerns or dismissing the anxiety you feel. It's about replacing speculation with facts, because informed citizens are empowered citizens. Let's start with the bedrock legal principle that governs everything else we'll discuss. Under the United States Constitution, citizenship lawfully obtained through naturalization is permanent and carries the same constitutional weight as birthright citizenship. This isn't a policy preference that changes with administrations. This isn't a regulatory guideline that can be rewritten by executive order. This is constitutional law, reinforced by over a century of Supreme Court precedent. When you completed your naturalization process, when you met the residency requirements, passed your English and civics examinations, underwent background checks, disclosed required information, and took the oath of allegiance, you became a United States citizen with full constitutional protections. Your status fundamentally changed that day. Think about what citizenship actually means in legal terms. It's not a visa with an expiration date. It's not a green card that requires renewal or can be revoked for extended travel. It's not conditional status tied to marriage or employment. It's not a permit that depends on maintaining certain requirements. Citizenship is a constitutional status that, once properly conferred, becomes permanent. It doesn't expire. It doesn't need to be renewed. And critically, it cannot be taken away simply because immigration enforcement policies become more aggressive or because political winds shift. This distinction is absolutely crucial to understand. Executive orders cannot override the 14th Amendment. Changes in enforcement strategy cannot rewrite constitutional protections. Congress cannot pass ordinary legislation that suddenly strips lawfully naturalized citizens of their status without meeting extraordinarily high constitutional standards. Your citizenship exists in a different legal universe than immigration status. Immigration status, whether that's a visa, work permit, or even permanent residence, is administrative. It's granted and regulated by agencies. It can be revoked under specified conditions. It exists within the executive branch's enforcement authority. Citizenship, by contrast, is constitutional. It's protected by the highest law in the land. The government cannot simply decide one day that your citizenship no longer counts. There are no administrative shortcuts. There are no policy changes that can undo it. Before we go further, I want to acknowledge something that doesn't appear in legal textbooks, but is deeply real for many naturalized citizens: the emotional residue of your immigration journey. If you spent years, perhaps decades, navigating the U.S. immigration system, you lived with genuine vulnerability. As a visa holder, your status could be jeopardized by job loss, administrative errors, or policy changes. As a permanent resident, you faced travel restrictions, renewal requirements, and the theoretical possibility of removal proceedings under certain circumstances. You learned to be vigilant. You learned to worry about every document, every timeline, every potential mistake. You checked case statuses obsessively. You felt genuine fear that something could go wrong and derail everything you'd worked toward. That psychological conditioning doesn't evaporate the moment you receive your naturalization certificate. Your nervous system carries the memory of that vulnerability. So when immigration enforcement intensifies and headlines scream about crackdowns, your body may react with the old familiar anxiety even though your legal status has fundamentally changed. Understanding this helps explain why so many naturalized citizens feel uneasy right now despite the strong legal protections they actually possess. The fear isn't irrational, it's based on years of lived experience in a vulnerable status. But the legal landscape has changed for you. You're no longer in that provisional category. Now we need to address the word that causes the most panic: denaturalization. This term spreads through communities, often without anyone fully understanding what it actually means legally. Let's break it down with precision. Denaturalization is the formal legal process through which citizenship obtained through naturalization can potentially be revoked. Notice I said potentially. This is not an automatic or administrative process. It's an extraordinarily narrow legal exception that operates under strict constitutional constraints. Here's what denaturalization actually requires. The federal government must file a civil lawsuit in federal court against a specific individual. In that lawsuit, government attorneys must prove, with clear and convincing evidence, that the person obtained citizenship through deliberate fraud, willful misrepresentation, or illegal procurement. This is not about policy disagreements. It's not about political beliefs. It's not about which country you came from or what language you speak at home. It's not about criticism of the government or participation in protests. It's not about changing political parties or exercising your First Amendment rights. Denaturalization is exclusively about whether your original naturalization was legally valid. Did you obtain citizenship through fraud? That's the singular question. To meet this standard, federal prosecutors would need to demonstrate evidence that you deliberately lied on your N-400 application about material facts, concealed serious criminal history that would have made you statutorily ineligible for naturalization, used a fraudulent identity or falsified documents, hid involvement in persecution, terrorism, or crimes against humanity, or intentionally omitted information that was legally material to the citizenship determination. Even when such allegations are made, denaturalization is not automatic. The process includes formal filing of a civil complaint in federal district court, full due process protections including the right to legal representation, discovery process where both sides gather evidence, evidentiary hearings where prosecutors must prove their case, application of a high burden of proof, clear and convincing evidence, and review by a federal judge who makes the final determination. This is not a streamlined administrative action. These cases typically take years to resolve. They require significant government resources, attorney time, investigative work, court proceedings. They involve constitutional due process protections at every stage. Historically, denaturalization cases are rare. Even in administrations that have prioritized immigration enforcement, the number of denaturalization cases filed annually is measured in dozens, not thousands or tens of thousands. The government simply cannot pursue these cases in large numbers because of the intensive individual litigation required. So if denaturalization is rare and constitutionally constrained, why do so many naturalized citizens feel vulnerable right now in February 2026? The answer lies in understanding enforcement visibility versus legal authority. The current administration has significantly escalated immigration enforcement operations. ICE activity is more frequent and deliberately more public. Workplace enforcement has increased. Detention policies have tightened. Border enforcement has intensified dramatically. Deportation operations targeting individuals without legal status or with final removal orders are being prioritized and publicized. This shift in visibility fundamentally changes how communities experience immigration enforcement, even when the underlying legal framework hasn't changed. When you see workplace raids covered extensively in the news, when social media amplifies every enforcement story, when removal operations are announced publicly rather than conducted quietly, it creates an atmosphere of instability and fear. This is where the critical distinction matters. Immigration enforcement operations target immigration status violations. Naturalized citizens do not have an immigration status, you have citizenship. You exist in a completely different legal category. You are not subject to deportation proceedings. You don't need to maintain visa status. You don't have renewal requirements. You don't face removal for criminal convictions the way permanent resident can. Your legal relationship with the United States is fundamentally different from someone who is undocumented, on a visa, or even holding a green card. But immigration policy debates are often framed with sweeping language. Crackdown on immigrants, strict immigration overhaul, deportation push. These phrases collapse multiple distinct legal categories into single emotional headlines. They don't distinguish between undocumented immigrants, visa overstays, permanent residents, and naturalized citizens, even though these categories have radically different legal protections. The result is predictable. People who spent years navigating a vulnerable immigration system instinctively feel like that vulnerability has returned when enforcement intensifies. But tone is not law, visibility is not a constitutional amendment. Enforcement intensity, however dramatic, does not rewrite citizenship protections. Let me address directly the three most common claims circulating in communities right now, because misinformation thrives in environments of fear and uncertainty. Claim 1: mass denaturalization is coming. The assertion that the government is preparing to strip citizenship from large numbers of naturalized Americans on a mass scale. This is legally impossible. There is no statutory mechanism for mass denaturalization. There has been no new legislation authorizing it. There has been no constitutional amendment enabling it. Denaturalization requires individualized federal court proceedings focused on fraud in the original naturalization. It cannot be executed through administrative action, executive order, or bulk proceedings. Claim 2: certain nationalities or religious groups are being targeted for citizenship revocation. While it's true that immigration enforcement priorities may focus on particular regions due to security concerns or visa overstay rates, denaturalization cases must be grounded in fraud or material misrepresentation during the naturalization process. Revoking citizenship based on race, national origin, religion, or ethnicity would be blatantly unconstitutional and would face immediate legal challenges. The Equal Protection Clause and First Amendment don't disappear during enforcement crackdowns. Claim 3: naturalized citizens need to take urgent protective measures. Claims that you need to renounce prior citizenship immediately, file special protective paperwork, pay for citizenship protection services, or register with organizations promising to safeguard your status. None of this is legally necessary. Your citizenship is protected by the Constitution itself, not by additional filings, fees, or private services. Fear-based businesses and scams invariably emerge during times of immigration anxiety. Be extremely cautious of anyone asking for money to protect something that is already constitutionally secure. Understanding what is actually happening versus what is not transforms how you respond to this environment. There is a real enforcement shift in 2026. There is genuine intensification focused on undocumented status and removal orders. There is heated political rhetoric around immigration. But none of these developments alter the constitutional permanence of lawfully obtained naturalized citizenship. When you separate enforcement optics from legal authority, the picture becomes substantially clearer and far less frightening.